years. So we have to look at the facts to decide whether the delay was reasonable or not. And the court, as you know, in equity, we look at the conscionable conduct of the parties. All right, next maxim. Is there any questions so far? No? Okay.
No.
Next, maxim equity looks to the intent rather than form. So equity does not really look at the formal instrument, but look at the intention or conduct of the parties. Intention of the parties is derived from the circumstantial evidence. Circumstantial evidence is largely derived from the conscionable conducts of the parties. So even in trust that you will learn next semester, trust is not necessarily need to be in writing, but if there is any conduct of the settlor to transfer or to convey the property for the benefit of beneficiary, that is enough. But of course, intention or conduct must be proven. So you must, because court can only rely on evidence, right? The court will only base the judgment on evidence. So the conduct of the parties must be proven in court. But if you have something in writing, of course, it's better, but not necessary in equity. Okay. Next, right, to illustrate the case of one Naimah and one Muhammad Nawawi, in this case, there was a conflict between two siblings, a daughter and the son. In this case, the father transferred the land to the daughter. Okay, but the father actually had the intention to give or to convey the land to the son. But because he was still an infant, so the land was transferred to the daughter. In this case, even though there was no express trust, there was no written trust, but there was a clear intention of the father to create a trust in favor of the son. Basically, the trust was given in favor of both daughter and son, but because the son was still an infant, the name of the son was left out. So the daughter argued that since your name was not there, so you had no right or no entitlement over the land. The court held that there was a clear declaration of the father that he had the intention to give a half share to his son. So the intention has been shown. There is no need to put in writing or be proven of the intention of the father here. Right, next is the maxim equality is equity. This is basically, right, hold on, the line is not stable. Okay. This maxim is applicable particularly in the case of matrimonial claims. When there are matrimonial claims, for instance, between the spouses, husband and wife, then both shall have equal right over the property. Of course, if you go back to your family law, then it depends on the nature of contribution of the parties. It could be direct or indirect, but the basic principle is that it will be divided equally. The reason was because based on the case of Cam and Cam, actually you can take other example of cases as well, where because the party share the same burden, so they have the equal title in the property or in the family home. In the case of Jones and Maynard, in this case, the husband, there was actually a joint account created by the husband before he joined military service. So, but the account was put under the name of the husband. The wife used some amount of money for an investment, so they were later divorced. In this case, the court held that the wife was entitled to the balance of the account and to the half of investment existing at the closing of the account, even though it was only registered under one name, but it was intended to be a joint account. So the right is divided equally between the husband and wife. Next case, this is actually a partnership case. In the case of Tai Kwong and Yap Koi Hee, in this case, a partnership was dissolved and a receiver was appointed by the court. In this case, there was argument on how the partnership property need to be divided and also debts and liability. So, you know, in partnership, all partners shall be sharing the asset and liability. If there is any debts or asset coming out from the partnership, that should be divided equally. There was no statutory provision about how the property would be, there was a statutory provision that the property should be divided equally based on section 47. Therefore, they should be divided equally. Meaning that there was no provision saying that one should have more burden to pay the debt and liability. Therefore, it should be divided equally between the parties because of no provision saying that, for instance, well, in partnership, you can have like the main partner who may have spent a lot of money for the partnership, but since there was no provision on that, so any asset or debts or liability shall be divided equally between the parties. Next maxim, he who seeks equity must do equity. All right, this maxim may relate to the previous maxim that I mentioned before. He who seeks equity must come with clean hands. For this maxim, it's different from those that he who seeks equity must come in clean hands. So the one who seeks equity must has acted fairly towards him or herself. For instance, in the case of injunction, okay, let's take an example where the plaintiff apply for an injunction, an interlocutory injunction. For instance, the land is sold to a third party without the knowledge of the first buyer. Was sold to a third party to a bona fide purchaser. So in the case of interlocutory injunction, the first equitable owner can apply for an injunction to stop the selling or the transfer of the property or the transfer of the title in the property to a third party. However, in the case of injunction as well, while the plaintiff making an application to stop or to prohibit the transfer of title in the property, the plaintiff must be able to make promise or what they call as the undertaking. So in the case of interlocutory injunction, the plaintiff must make an undertaking that in the case that he lost the injunction case, he must be able to pay damages to the owner or to the third party. So if the plaintiff cannot make such undertaking, the court will not entertain the application for the injunction. So the plaintiff here must act fairly. Meaning that the plaintiff must be able to make an undertaking to pay damages if he fails in the injunction case. If he cannot fulfill or cannot make that undertaking, then the injunction would not be granted, or the injunction would not be ordered to the plaintiff. In the case of Tinsley and Milligan, there were basically lesbian couple. So in English law, even though you are same-sex couple, you are not married, you still have your right under cohabitation. So under cohabitation, you can claim your right exactly like a married spouse, meaning that they have claimed their right for maintenance, right for property, and etc. etc. The same thing like in normal marriage. So in this case, they have agreed, both of them have agreed to bought a property and to have a co-ownership. However, as in the previous case, the property was registered under the name, under only one name, which is Miss Tinsley's. In this case, the reason why they registered under one name only because they want to make a fraudulent claim for the benefit of Miss Tinsley. So there was a reason why they were registered under one name, not under two names. Okay, so they broke up, and Miss Tinsley sought an action to chase out Miss Milligan out of the property. Miss Milligan instead filed a counter claim to claim the half share of the land, meaning that let us share in the property. So they agreed that there's going to be a co-ownership in the property, but Miss Tinsley, because of the conflict they had, Miss Tinsley denied the right of Miss Milligan. The court held that both parties had equal right over the land. So in this case, Miss Milligan had a good or valid claim as a joint equitable owner. Even legal owner here is Miss Tinsley, right? Because the land, the property was registered under her name. So Miss Milligan became the equitable owner. In this case, even though she just an equitable owner, but she had shown lawful contribution to the purchase price. So the reason that they registered the land, the property only under one name to avoid social security claim does not affect the claim of Miss Milligan in the property. Therefore, the court decided that the property should be divided equally because there was already agreement between the parties. Next case, Harden and Bellius. In this case, A was a registered proprietor of share in a company. He held the shares on bare trust for R as they were not wholly paid up. Okay. The concept of bare trust, basically, a trustee, in this case, A is the proprietor and A also is a trustee. Okay, when A also is a bare trustee, bare trustee, where A just hold or just keep the property in trust of the other people. And when you say A here is a bare trustee, A did not have anything but just to keep the property in trust for the other people. So I hope that makes sense. All right. So the shares were not fully paid up, and the company went into liquidation. R wanted A to pay for the debts. Okay. So in this case, bare trustee actually did not have any. Bare trustee just keep the property for the benefit for others' benefit. But when it comes to claim for R here, wanted A to pay for the debts. But the court held that A was just a bare trustee. Therefore, any claim for debt should be paid personally by R, not by A. Because R should bear the burden of any liabilities being taken against R. So it should not be borne, the debt should not be borne by A because B is just a bare trustee. So when you say bare trustee should not be liable for any debts of other people. Here is R. So here the court held that R was bound to indemnify A personally because A has paid the debt on behalf of R. But that does not mean that A would be liable for any subsequent claim against R. R has to pay back, indemnifies like pay back for what A has paid for the the share, because the share was not fully paid up. A was like the savior lah for the company. That's why A became the bare trustee. Okay, if A was not there, then the company would have bankrupt or would have gone liquidated earlier than that. Okay, right. Next case, Chapel and Times newspaper. There was a strike launched by the employees against the press company, against the employer. The employer had threatened to fire the employees if they did not stop the strike. So the employees went to court and applied for an injunction. The court, however, rejected the injunction application made by the employees because they have not stopped the strike. So if they have stopped the strike, then only they will have acted fairly towards the employer, or only they can get their rights in injunction. Next, equity will not permit the provisions of a statute intended to prevent fraud to be used as an instrument of fraud. All right, what this maxim means, basically, when the parties manipulate the provision in the statute for the purpose of committing fraud, equity would not assist them. In the case of Ai Ming and Chan Ching Chuan, in this case, there was an arrangement between the plaintiff and defendant that the company, that the plaintiff was put as the beneficial owner of the share. So they need 2 Malaysian directors to get the company registered. However, there was actually something like a shame or a fraud happening between the parties. So when they signed the trust, when the power was given to the lawyer, they were tainted with illegality. That means it was illegal document. So in this case, even though there was a proper registration of the company, but since there was manipulation of the statute for fraudulent purpose, the transaction of registration was considered illegal. Therefore, the company registration was not pursued in this case. So the manipulation, in the case where there is any breach of contract, they cannot be enforced because in the first place, there was already misuse or manipulation of the statutory provision. All right, this case is quite interesting. Bannister and Bannister, an English case. Bannister and Bannister is really a conflict between family members as well. Miss Bannister inherited 2 cottages upon the death of her husband. So he sold both cottages to her brother-in-law at a lower price, which is £150 lesser than the market value, after the brother-in-law had given an oral assurance that she could live there in her cottage rent-free for as long as she wished. However, later the brother-in-law sought an order to chase out Miss Bannister from the cottage. Mr. Bannister, in this case, held the cottage on constructive trust for Miss Bannister, who had a life interest in the property, and she could remain there for free. Okay, in this case, constructive trust means you keep the property. You can claim under constructive trust when someone has misused the promise. So in this case, there was agreement between them that even though the cottage was sold to the brother-in-law, but she could stay there like forever as long as she wants for free. But Mr. Bannister broke the promise. So on the constructive trust, where it was agreed between the parties that there shouldn't be any issue if the Miss Bannister would like to stay there for free or as long as she wish. So in this case, the reason, okay, constructive trust is where the reason causes happen when Miss Bannister agreed to sell the property at a lower price so that she could remain there. Hello, the line, okay. So the reason why Miss Bannister agreed to sell the property is because the brother-in-law agreed to take the property at a lower price. And so there was an agreement. She sold the property at a lower price. She could stay there for free as long as she wanted. But there was a fraud of Miss Bannister here where Miss Bannister denied the right of the life interest right or life interest of Miss Bannister in the land. So in this case, a valid trust had been created, even though it's just a constructive trust. Constructive trust means you keep the property. You, in this case, you can say Mr. Bannister is a trustee, but the property is not really transferred or conveyed to him because he just agreed to buy the property based on the promise that she also can remain on the land she wants. So the trust had been created here even though the trust was not put in writing or satisfied the formality requirement under the Law of Property Act 1925. Next, equity looks on that as done which ought to be done. This one we have covered before, basically based on the case of Walsh and Lonsdale. So equity look on that as done, which ought to be done means the unregistered transaction that ought to be done, they can be enforced as if it is registered. In the case of Walsh and Lonsdale, the lease was unregistered, right? If you still remember the case. But there was agreement that the rent should be paid upfront if it was demanded by the landlord. So the lease was not registered and it did not fulfill the requirement basically of the Property Act, but it was still a valid lease. The court held that it was still a valid lease because the lease, the equitable lease was as good as a legal lease. I would not explain this case because we have done a few times with this case before. But if you have any questions or if you require clarifications, please just let me know. Right, next is equity imputes, an intention to fulfill an obligation. All right, basically you know that equity is based on intention. So intention can be derived from circumstantial evidence or conducts of the parties. So you cannot determine exactly or precisely based the intention as if it was formally written. So as long as you can derive the conduct of the parties that can say that there is obligation between the parties, that should be enough. For instance, if there is a transaction between the equitable owner and the landowner, that the equitable owner that had paid some amount of money, that is good enough to say that there is intention to buy the land, even though there was no registration of the title yet, even though there was no caveat yet entered on the land. So that the act of spending, the act of paying the price of the land is good enough to say that there was obligation, there was an intention to enter into a contract between the parties. But of course, if you have a contract, then you can just follow more closely the terms and conditions of the contract more precisely, I mean. But if in equity, the conduct of the parties are good enough to say that equity can enforce the obligation of the parties in a contract based on the conduct of the parties. In the case of Soden and Soden, In this case, there was a marriage settlement between the spouse where the husband agreed to put property for the benefit of themselves, husband and wife, and also for the children. So the husband promised to pay £2,000 to trustee, with which they would buy property to provide income for his wife in the event of his death. When the husband died, the husband bought a property after their marriage and died. The court said that the property that he bought was actually part of the, even though it was not stated clearly, but based on the conduct of the husband, that the property bought later after the marriage was also considered as part of the performance of the trust, performance of the marriage settlement. Marriage settlement and trust are the same thing. I'm referring to the same thing. So even though it's not exactly the same amount, but looking at the conduct of the husband, the court held that it was part of the marriage settlement. Next, the last maxim is equity will not perfect an imperfect gift, or equity will not assist a volunteer. So in an example of trust again, the conveyance of title from the trustor, from the settlor to the beneficiary must have consideration. You know, in a contract, you must have consideration. If there is no consideration, then you cannot say there is a valid trust or valid gift. If there is an agreement to create trust, the trust property must be vested in the trustee for equity will not perfect an imperfect gift. Meaning that if in a trust, basically the trustor will the trustee will keep the property in trust of the trustor, right? In trust of the settlor for the benefit of the beneficiaries. So the trustee must be able to convey the title to the beneficiary. If it is not perfected, then if it is not done, then it cannot say that there is imperfect gift. So you cannot say you want to give something, but you have nothing in your hand to give, or nothing in consideration in return to the other party. The case of Milroy and Lott, in this case, to make it short, in this case, there was actually a trust here in the form of shares. The share was put in the Bank of Louisiana here to hold on trust for him. So the settlor appointed a lawyer. A lawyer here becomes a trustee to handle the transfer of share. Okay. Under the bank's constitution, there was a requirement that to effect the transfer of share from the settlor to beneficiary, the share must be registered. However, in this case, the settlor did not manage to transfer the share before his death. So the question here is, there was a claim letter by the beneficiary against the attorney as the trustee. In this case, the failure to register the share was considered as, or was rendered the gift as imperfect, meaning that you cannot say there was a trust here. There was already an agreement to transfer the share to the beneficiary. However, because of the failure of the settlor to register the share, so that makes the gift imperfect. Okay, even though actually the trustee had a valid power to transfer the title, but because the settlor failed to fulfill the requirement of the bank, so the gift became imperfect. So imperfect gift cannot give or cannot vest the title, the right from the settlor to the beneficiary. Unfortunately, there was an imperfect gift here, so the trust was not created. That's all from me. Any questions from the class? I'm opening the mic. Hold on. Any questions?
No.
Ada soalan? Semua boleh buka mic ni.
No.
No.
Okay, if there is no questions, I guess that's all from me today. So have a good day. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Waalaikumsalam.